Hello and welcome to Unacademy. This is the last lap and session number 2. Yesterday we discussed 25 MCQs. Today we'll discuss 25 more, 50 MCQs on the pattern of the PYQs. Without wasting time, let's look at question 26. Which of the following are not the discretionary powers of the governor of a state? Sending a report to the President of India for imposing the President's rule, it is a discretionary power. Appointing the ministers, it's not a discretionary power. Reserving certain bills passed by the state legislature for consideration of the President of India, it is a discretionary power. Making the rules to conduct the business of the state government, it is not the discretionary power. Basically, the governor can do certain things without the aid and advice of the Council of Ministers. That's what we call the governor acting in his discretion. So when the president sends a report, when the governor sends a report to the president asking the president to impose a president's rule, the governor is not acting on the aid and advice of the chief minister and Council of Ministers. But in appointing the ministers, the constitution is clear. The chief minister shall be appointed by the governor, and on the advice of the chief minister, other Council of Ministers shall be appointed. A bill passed by the state legislature can be reserved by the governor for the consideration of the president. This is also where the governor is acting in his discretion. But making rules for the conduct of the state government, the business of the state government, that is done on the advice of the government. So which of the following are not the discretionary powers? 2, 4, C is the right answer. Question 27. The Legislative Council of a state in India can be as large in size as 1/3 of the Legislative Assembly of that particular state. Legislative Council, minimum we can have 40, maximum we can have is 1/3 of the strength of the Legislative Assembly. So Legislative Council of a state in India can be as large in size as 1/3 of the Legislative Assembly of that particular state, correct? The chairman of the Legislative Council is elected by the members of the Legislative Assembly by simple majority. By the members of the Legislative Council by simple majority. The chairman of the Legislative Council is elected by the members of the Legislative Council by simple majority. And you can be removed. Removal is by effective majority. Removal is by the majority of all the then members of the House. So that is by effective majority. The chairman of the Rajya Sabha is the Vice President of India, elected by both the houses. But the chairman of the Legislative Council is elected by the members of the Legislative Council. Similarly, deputy chairman also. So how many statements are correct? A, one only is the right answer. Great. Question 28. Consider the following statements regarding money bills. A money bill can be introduced in either House of Parliament with the recommendation of the President. Can be introduced only in the Lok Sabha. Incorrect. The Rajya Sabha can recommend amendments to a money bill, but such recommendations are not binding on the Lok Sabha. Correct. But sir, Rajya Sabha cannot amend a money bill. Rajya Sabha cannot reject a money bill. The Rajya Sabha can only make recommendations. That's exactly what is mentioned here. Can recommend amendments, which means these are recommendations and they are not binding on the Lok Sabha. Correct. If the Rajya Sabha does not return a money bill within 14 days, it is deemed to have been passed by both the houses. Yes, the Rajya Sabha's role is inferior. And we say the maximum you can do is you can delay a money bill for 14 days, after which it shall be deemed to have been passed by both the houses. According to the Constitution, Speaker's decision on whether a bill is a money bill is final and cannot be questioned in court, which means there is no judicial review. That's correct though. But sir, there is a judicial review on money bill. There is, but that's the interpretation by the Supreme Court. Jairam Ramesh petition. But that doesn't mean Constitution is not clear. Constitution is clear on this. That this bill, once it is transmitted to the Rajya Sabha, it is certified by the Speaker as a money bill. And that certificate is final and cannot be questioned in any court. That's what the Constitution says. So 2, 3, 4, because the Constitution says decision is final. 2, 3, 4, how many statements are correct? C, only 3. according to constitution. But if it was a general statement, the decision of the speaker certifying a bill as a money bill is subject to judicial review. That anything can be subject to judicial review. So 234C is the right answer. 29. Consider the following statements about State Council of Ministers. The Chief Minister is appointed by the Governor, and other ministers are appointed by the Governor on the advice of the Chief Minister. Correct. This is the straight wording of the Constitution. The Council of Ministers in a state is collectively responsible only to the Legislative Assembly. Exactly, that's what parliamentary democracy means. Council of Ministers collectively responsible to the lower house. If a state has a legislative council, the Council of Ministers is responsible to both the houses? No, even then it is responsible only to the Legislative Assembly, accountable only to the Legislative Assembly. A minister who is not a member of either house must get elected within 6 months. How many statements are correct? B, 2 only. But sir, isn't the statement 4 correct? Even if you're not a member of the state legislature, you can be appointed as a minister, but within 6 months, you have to become a member of the state legislature. What if you are appointed as a minister, but you are not elected to the Legislative Assembly, you are nominated to the Legislative Council? The clear-cut wording in the Constitution is you should become a member within 6 months. And you become a member by either through election, which means you're an elected member, or through nomination, which means you are entering the Rajya Sabha through nominated category or Legislative Council through nominated category. So you don't must get elected, no, must become a member within 6 months. That's why B, only 2 is the right answer. Question 29. Right? Must become a member, not necessarily must be elected. Consider the following statements regarding parliamentary privileges. Freedom of speech in Parliament is subject to the rules of procedure. Freedom of speech under Article 105 Constitution says no matter what you say and how you vote, you cannot be inquired in any court of law. But that does not mean you can say whatever you want to say inside the Parliament. It's subject, your speech and conduct is subject to the rules of the business and procedure of the House. Which means, can you raise slogans? No. Can you use abusive language? No. Can you show placards? No. Can you shout slogans? No. Because these are subject to the rules. Members of Parliament cannot be arrested when Parliament is in session. This is such a general statement and as such is incorrect. Yes, if you are arrested or if you are accused in a civil case, then maybe you will not be arrested when the Parliament is in session. But if you are accused in criminal case or contempt case, even during the session of the Parliament, you may be arrested. The only thing is that if you are present inside the Lok Sabha, you need the Speaker's approval to arrest you. But you can be arrested even when Parliament is in session. Parliament has the power to punish only outsiders for the breach of privilege. No, Parliament can punish even the members for its breach. Courts can inquire into the proceedings of the Parliament to determine if they were conducted in accordance with the rules. This is separation of powers. The courts cannot inquire into the conduct and the proceedings of the houses. No. How many statements are incorrect? 3 statements are incorrect. C is the right answer. Question 30, C. Good job. 31, the Rajya Sabha. Consider the following statements about the Rajya Sabha. The Rajya Sabha can alone initiate a resolution for the abolition of All India services, for creation of All India services. But there is no such thing as abolition of All India services, which means an All India service can be abolished by Parliament. So for that, Rajya Sabha's approval is not required. Prior resolution is not required. But for the creation, since the Rajya Sabha represents the interest of the states in the Parliament, for the creation of a new All India service, you need Rajya Sabha's approval before Parliament can initiate the law. So this statement is incorrect. Rajya Sabha can alone initiate resolution for the abolition of All India services? No. For creation, yes. For abolition, no. The Rajya Sabha has equal power with Lok Sabha in the removal of the Vice President. Rajya Sabha has a special power. Because such a motion can be introduced only in the Rajya Sabha. In the Rajya Sabha, we require effective majority. This resolution should be acceptable. Motion should be accepted to the Lok Sabha by simple majority. So long story short, Lok Sabha has an inferior role in the removal of the Vice President. A resolution passed by the Rajya Sabha with 2/3 majority can empower Parliament to legislate on state subjects. That's what Article 249 tells you. In national interest, Parliament can legislate on state list. The Rajya Sabha can delay a non-money bill for the maximum period of 6 months. Non-money bills are financial bills, ordinary bills, and such bills can be delayed by the Rajya Sabha for a period of 6 months. After which we say that on this bill there is a deadlock. And to resolve this deadlock, there can be a joint sitting. But there can be no joint sitting when it's a constitutional amendment bill, because constitutional amendment bill must be passed by both houses of the Parliament by special majority. So on constitutional amendment bills, we can say that Rajya Sabha cannot delay the passage of a constitutional amendment bill for a maximum period of 6 months. The Rajya Sabha has an equal role with respect to Lok Sabha when it comes to constitutional amendment bills. But on financial bills and ordinary bills, yes, maximum you can delay 6 months. After that, there is a joint sitting. So how many statements are correct? 2 statements are correct. B is the right answer. 31B. Rajya Sabha can alone initiate resolution for the abolition of all India services. No, it's for the creation. Rajya Sabha has equal power in vice president. No. A resolution passed by Rajya Sabha with 2/3 majority can empower Parliament to legislate on state subjects. Yes, Rajya Sabha can delay a non-money bill for a maximum period of 6 months. Yes, 3-4. B is the right answer. 32. Consider the following statements regarding the President's power of pardon. The President can grant pardon in all cases where the punishment is for an offence against the Union law. Correct. The President's pardoning power extends to the cases of court-martial. Correct. Governor cannot pardon a death sentence. Yes, the Governor can commute death sentences. How many statements are correct? All the 3 statements are correct. 32C is the right answer. President can grant pardon in all cases where punishment is for an offence against the Union law. The President's pardoning power extends to case of court-martial. The Governor cannot pardon death sentences. Correct. 33. Consider the following statements about the questions in Parliament. A starred question requires an oral answer and hence supplementary questions can be asked. A starred question which is differentiated with an asterisk mark requires an oral answer. If it's an oral answer, there can be supplementary questions. 5 supplementary questions can be asked. A short notice question is one which is asked by giving a notice of less than 10 days. That's what a short notice question is. That's why it is short notice. Questions can be asked on matters that are under adjudication by a court. 33B is the right answer, because according to the rules, if there are matters which are sub judice, on such matters, questions cannot be raised in the Parliament. Question 34. Consider the following statements about the State Legislative Assembly. The minimum strength of a Legislative Assembly is fixed at 60. Minimum 60, maximum 500, although there are exceptions. For example, Goa, Sikkim. But generally, the statement is correct. The minimum strength of the Legislative Assembly is fixed at 60 members. The Speaker of Legislative Assembly can be removed by a resolution passed by absolute majority of all the members. Absolutely incorrect. This is effective majority, which means majority of all the then members of the House. The salaries of members of the state legislature are charged on the consolidated fund of the state? No. Are made on the consolidated fund, not charged. If it was a charged expenditure, then Legislative Assembly could not have voted, could have only discussed this charged expenditure. A member can lose membership if absent from all sessions for a period of 60 days without permission. Correct. How many statements are correct? B, 2 only is the right answer. 34B. 35. With a reference to the Business Advisory Committee of the Lok Sabha, consider the following statements. It allocates time for discussion of bills. Business Advisory Committee of Lok Sabha consists of 15 members, including the Speaker, headed by the Speaker. It is chaired by the Speaker. Its decisions are not binding on the House. Ministers are members of the committee. No. How many statements are correct? B. 35B is the right answer. With reference to the Supreme Court of India, consider the following statements. The Supreme Court is a court of record. Yes, which means its records are used as proof, admissible as evidence. They do not require any further proof. And you can punish people for contempt. That's what the court of record is. The power to punish for contempt flows from its status as a court of record. Yes. That's why you're called the court of record. Although contempt power is given to the courts, that is regulated by the Contempt of Court Act, Criminal Contempts of Court Act 1971, but it is because you are a court of record, and that's how Supreme Court and High Courts, they act as court of records, which means only these two courts can punish you for contempt. That does not mean you can commit contempt to the district court. But High Court concerned can punish you if you have committed contempt to the district court. Parliament can curtail the contempt powers of the Supreme Court. Parliament can regulate. That does not mean Parliament can curtail. Parliament can enhance, regulate, but not curtail. Because Supreme Court has its own contempt powers. It flows because of its status as a court of record. The records of the Supreme Court are admissible as evidence without further proof. Yes. How many statements are correct? C. 36C is the right answer. Great. With reference to the jurisdiction of the Supreme Court, consider the following statements. Advisory jurisdiction can be exercised on questions of fact or law. Law of fact. Yes, Article 143. Such a case, such a presidential reference can be heard by 5 judges, minimum of 5 judges. The president is bound by the Supreme Court's advisory opinion. It's only an opinion, advice. It's not binding on the president. Disputes between states fall under original jurisdiction. Correct? Enforcement of fundamental rights falls under appellate jurisdiction. No, it falls under original jurisdiction. How many statements are correct? Only 2. B. 37B is the right answer. Great. Question 38. With reference to judicial review, consider the following statements. Judicial review is explicitly mentioned in the Constitution. No, we can trace the concept of judicial review to Article 13, Article 32, Article 226, but it is not explicitly mentioned. Yet Supreme Court has said that judicial review is part of the basic structure in Minerva Mills 1980. Laws in the 9th schedule are completely immune from judicial review. No, the laws, if they are placed till 24th April 1973, the landmark Keshavananda Bharati judgment, those laws survive. No scrutiny. But if a law is placed in 9th schedule after this date, after the Keshavananda Bharati judgment, there is judicial review. You are not completely immune from judicial review. Judicial review applies to both legislative and executive actions. What is judicial review? The review by the courts of the constitutionality of the laws and executive actions. That's what judicial review is. So 2 statements are correct. B, 38B is the right answer. Good job. With reference to the Election Commission of India, consider the following statements. The Election Commission is not a permanent constitutional body. It is a permanent constitutional body. The Constitution fixes the number of election commissioners. The Constitution does not fix the number of election commissioners. It is the law enacted by the Parliament in 1991, and then this law was repealed in 2023, which says that Election Commission consists of Chief Election Commissioner and not more than 4 election commissioners. The Chief Election Commissioner enjoys security of tenure similar to a Supreme Court judge. Now listen to me carefully. The Chief Election Commissioner enjoys tenure similar to a Supreme Court judge. The Chief Election Commissioner, if it was tenure, the tenure of the Chief Election Commissioner is 6 years or 65 years, whichever is earlier. But the tenure of the Supreme Court judge is not 6 years at the Supreme Court or 65 years, whichever is earlier. But here it is not saying tenure only, it's saying security of tenure. Can a Supreme Court judge be arbitrarily removed by the president? No. Can a Chief Election Commissioner be arbitrarily removed by the president? No. Can be removed only on the grounds of proved misbehavior or incapacity based on the resolutions passed by both houses of the Parliament by special majority. So statement 3 is correct. Other election commissioners can be removed in the same manner as the CEC. No. Other election commissioners are removed on the recommendation of the CEC. So how many statements are incorrect? So Election Commission is not a permanent constitutional body. It is a permanent constitutional body. So Election Commission is not a permanent constitutional body. The statement is incorrect. Constitution fixes the number of election commissioners. Constitution does not fix the number of election commissioners. The chief election commissioner enjoys security of tenure similar to a Supreme Court judge. Yes. And other election commissioners can be removed in the same manner as the CEC. No. How many statements are incorrect? C. 39C is the right answer. The Election Commission is not a permanent constitutional body. It is a permanent constitutional body. So C is the right answer. Question number 40. With reference to the official language provisions, consider the following statements. Hindi in Devanagari script is the official language of the Union. Hindi only? Or English also? Both Hindi as well as English. So Hindi in Devanagari script is the official language of the Union, correct? English was to be replaced compulsorily after 15 years? No. Constitution said for 15 years, English will be used alongside Hindi. But after 15 years, only Hindi will be the official language of the Union. But Parliament can, through a law, provide for the continuance of the usage of English beyond 15 years. So it is not was to be replaced compulsorily after 15 years? No. Because Constitution has a provision that Parliament can provide for continued use of English through a law. But that is not a constitutional amendment. That is through an ordinary law, not through a constitutional amendment. States are free to adopt any language for the official purposes, provided the language is in the 8th schedule. Even if the language is not in the 8th schedule, states can adopt that language as the official language. So this statement is incorrect. How many statements are incorrect? C, 40. C is the right answer. Great. Consider the following statements regarding the jurisdiction of the Supreme Court. The Supreme Court has original jurisdiction in disputes between the Government of India and one or more states. Correct? The Supreme Court can transfer cases from one high court to another in the interest of the justice. Yes. For example, Jayalalitha case, Gujarat riots case. Yes. The President's decision on the age of a high court judge is final and cannot be questioned. Yes. But here you have to consult the Chief Justice of India. Consult the Chief Justice of India. The Supreme Court can withdraw a case pending before a high court and dispose it of itself. Yes. How many statements are correct? All the statements are correct. D, 41. D is the right answer. Consider the following statements regarding writs issued by the Supreme Court. Habeas corpus can be issued against both public authorities and private individuals. Yes, whether the violator is a private entity or a state, habeas corpus can be issued. Mandamus lies against a private individual who performs a public duty. Mandamus can be issued against a private company also if it is performing a public duty. So this statement is correct. Prohibition and certiorari. Difference is both prohibition and certiorari, number one, can be issued by a superior court against the subordinate court. Now the difference is in prohibition, the final order has not been given yet. But in certiorari, if the final order has been given, the court can issue the writ of certiorari to certify that that proceeding will not, that verdict will not continue, that order will not continue. That's the difference. Prohibition is issued by the superior court to prevent a subordinate court from exceeding its jurisdiction and prohibiting it from proceeding further. Whereas certiorari can be issued only after the court has passed an order. All the statements are correct. D is the right answer. Question 43. With reference to Panchayati Raj institutions, consider the following statements. The Gram Sabha is a constitutional body. Yes. And all the registered voters in that village must come together to create this Gram Sabha. All the registered voters are automatically part of the Gram Sabha. It's a constitutional body. Reservation for women is constitutionally mandated. Yes, not less than 1/3. Can be more than 1/3, but not less than 1/3 at all the levels. Panchayats are institutions of self-government. Yes, but whether they are institutions of self-government in reality or they are struggling because they are under the influence or at the mercy of the state and the union government, that's a separate matter, but these are units of rural local self-government. State Finance Commission recommendations are binding on the states. No. How many statements are correct? C, only 3. Because just like Union Finance Commission, State Finance Commission recommendations are also not binding on the states. Question 44. Consider the following statements regarding the doctrine of constitutional silence and legislative competence. Parliament can legislate on a state list subject only with the approval of the Rajya Sabha in all circumstances. There are circumstances where Parliament can legislate on state lists without Rajya Sabha's approval. When? When the state is under President's rule. When there is a national emergency in place. When 2 or more states are requesting Parliament to enact a law. Yes, in one instance, under Article 249, when the Rajya Sabha passes a resolution saying it is in national interest for Parliament to legislate on state list. But Parliament can only legislate on state list only with the approval of the Rajya Sabha. This is, and that too in all circumstances, this is incorrect. If a matter is not enumerated in any of the 3 lists, the residuary power can be invoked by the union. Yes, that's how we deviate from the US model of federalism, where if there is an item which is not mentioned anywhere in any of the lists, then that residuary subject lies with the states. But in India, it lies with the union. When both Parliament and state legislature have legislated on a concurrent list subject, the state law prevails if it received presidential assent. For example, so how many statements are correct? First, B, only 2. 44, B is the right answer. If Parliament has enacted a law, state legislature has enacted a law on a concurrent list, it's the parliamentary law which will prevail. But, for example, it's a criminal procedure, civil procedure, marriage, divorce, education. If a law has been enacted, if a bill has been passed by the state legislature on this concurrent list item, but that bill has been reserved by the governor for the consideration of the president, and if the president has given assent to this bill, then for that state, that law will prevail, not the parliamentary law. That state law will prevail, which has received the president's assent. 45. To initiate a motion to remove a judge of the Supreme Court, at least 100 members of the Lok Sabha or 50 members of the Rajya Sabha must consent to such a motion. If it was and, then the statement is incorrect. This can be introduced in Lok Sabha. 100 members of the Lok Sabha has to sign this motion. It can be introduced in the Rajya Sabha. 50 members will have to sign this motion. The Chief Election Commissioner can be removed on the same ground and in the same manner as the Supreme Court judge, but other election commissioners can be removed on the recommendations of the CSE. Correct. The CAG can be removed on the grounds of proved misbehavior or incapacity certified by the Supreme Court. No. CAG is removed in the same manner and on the like grounds as the judge of the Supreme Court, which means under the Judges Inquiry Act, which means this is where no certificate by the Supreme Court is required. Although there is a committee which is set up, but certification by Supreme Court, inquiry by the Supreme Court is not necessary. If you have to remove a UPSC chairperson on the grounds of proved misbehavior, then you have to refer this matter to Supreme Court for an inquiry. And once Supreme Court gives an inquiry, completes the inquiry and certifies that yes, this UPSC chairperson is guilty of misbehavior, then President is bound to remove the UPSC chairperson. But not in case of the CAG. You can be removed on proved misbehavior and incapacity, but based on the resolution passed by both houses of the Parliament, not the inquiry of the Supreme Court. The governor can be removed by the President at any time as the governor holds office during the pleasure of the President. Yes. How many statements are correct? C, only 3 is the right answer. Question 45, only C. Although the Supreme Court has said in BP single that the removal of the governor by the President cannot be arbitrary decision. Just because there has been a change in government at the union and now you are removing the governor appointed by the previous dispensation, this is arbitrary. On this ground that we are appointing more qualified governors as compared to the existing governor, this is also not a ground. There has to be tangible, solid ground for the removal of the governor. 46. Ordinary law cannot be challenged in the Supreme Court on the grounds that it violates the basic structure doctrine. Ordinary laws can be challenged on only 2 grounds: for the violation of the fundamental rights or the legislative competence. If the body which has enacted that law was not competent to enact that law, it was not in your jurisdiction to enact such a law, On this ground, ordinary laws can be challenged. On the grounds of violation of the basic structure, only constitutional amendment acts can be challenged. Subordinate legislation can be challenged for violation of fundamental rights only if the parent statute is also unconstitutional. IT rules can be declared unconstitutional by the Bombay High Court, despite the fact that IT Act is constitutional. What does that mean? That means even if the law is valid, constitutional, but the rules made under the subordinate legislation, they are violative of the fundamental rights. The rules can be declared unconstitutional. The doctrine of eclipse applies to pre-constitutional laws that are inconsistent with fundamental rights. Correct. How many statements are correct? B, only 2. There's a pre-constitutional law. Can it continue beyond 26th January 1950? Yes, as long as this pre-constitutional law is in agreement with fundamental rights. The moment you violate fundamental rights, these laws are eclipsed by the limits imposed by fundamental rights. Now, if, for example, there is a pre-constitutional law which violates, let's say, a fundamental right, which is right to property, which means this law is eclipsed by right to property. Now, what if right to property ceases to be a fundamental right? This pre-constitutional law continues because it was only eclipsed by this limitation of right to property. Now that that limitation is gone, this law continues. That's what we call doctrine of eclipse. 1 and 3, B is the right answer. 46. Good. 47. Nota option was introduced by the Election Commission following a Supreme Court directive. Yes, it was not implemented by Election Commission on its own. It was pushed by the courts. The right to vote is a constitutional right under Article 326, whereas the right to contest elections is a statutory right. Both right to vote as well as right to contest elections is a statutory right, provided by the Representation of the People Act 1951. EVMs have statutory backing under the Representation of the People Act. How many statements are correct? B, only 2. You would know that when in 1984 in a by-election to Parur constituency in Kerala, EVMs were used for the first time. Matter went to the court. The court declared this election as void, saying that since the law Representation of the People Act explicitly talks about elections through ballot papers, there is no bencher of EVMs. On this ground, the election was declared void. Later on, the law was amended, and in 1989, the law was amended to provide statutory status to EVMs. So 1 and 3, only 2 is the right answer. 47B. 48. The Supreme Court held in L. Chandra Kumar case that judicial review by high courts under 226 and 227 or over tribunal decisions cannot be completely excluded. Yes. High courts, we have to preserve the eminence of the high courts. You can't bypass the high court and move directly to the Supreme Court. Judicial review by high courts are important. Tribunals can be established only for matters listed in the union list and concurrent list, not for the state list subjects. No, can be set up on state list subjects as well. Urban land sealing, taxation matters, on state subjects as well. The National Company Law Tribunal was established under Article 323B of the Constitution. Yes. Administrative tribunals established under Article 323A have jurisdiction over disputes related to recruitment and conditions of service of persons appointed to public services. 323A, under which administrative tribunals are established, which means, for example, CAT or SAT, which deal with disputes related to recruitment, conditions of service of people appointed to public services. So 1, 3, 4 are correct. C is the right answer. Last 2 questions. Consider the following statements regarding the interrelationship between different emergency provisions. President's rule under Article 356 can be proclaimed in a state even when national emergency under Article 352 is already in operation. So there is already Article 352, national emergency. Can we proclaim president's rule in that state? Yes. What if the government is not possible? Yes. Financial emergency under Article 360 automatically comes into the force when national emergency is proclaimed on the grounds of war or external aggression. That has nothing to do with financial emergency. During President's rule, fundamental rights of citizens in that state can be suspended by presidential order under Article 359. President's rule has nothing to do with violation of fundamental rights. Or should we say that your fundamental rights are unaffected during President's rule? Your fundamental rights are restricted during national emergency, but not during President's rule. A proclamation of national emergency on the ground of internal armed rebellion in one state does not require approval of the entire parliament, but only members from the affected state. Emergency can be imposed in the entire country, or in one state, or any part of that state. Even then, even if it is imposed on only one part of the state, the approval is required in both houses of the parliament by special majority. So not only from the members from the affected state. So how many statements are correct? Only one is the right answer. Right? Great. Last question. During national emergency, union can give directions to states on any matter, but the state governments are not suspended and continue to function. Yes, in fact, the term of the Legislative Assembly is also extended 1 year at a time. The president can modify constitutional distribution of revenues between union and states during financial emergency without requiring a constitutional amendment. Yes. Laws made by Parliament under Article 250 during national emergency override state laws on the same subject even after the emergency ceases. No, once the emergency ceases, this law enacted by Parliament on state list continues only for 6 months. But if a law is enacted by the Parliament on a state when the state was on President's rule, that law continues, even after the President's rule is revoked. Which means laws made by Parliament under Article 250 during emergency override state laws even after the emergency ceases? No. A proclamation of emergency issued on the grounds of armed rebellion can be confined to a specific part of India rather than applying to the entire country. Yes. How many statements are correct? C, because emergency may not be, as I told you previously, applied on the entire country. It can be imposed in any part of that state or only in one state. These were 50 MCQs on the pattern of the PYQs. And if you have been able to solve these questions, if these 2 sessions were of some help to you, consider liking this video, subscribe to our channel if you haven't yet, and all the best for the prelims on Sunday. Thank you for watching. Goodbye.